Good evening, everybody, and thank you very much to the organisers for inviting me here today. My name is Fergus Ryan, and I'm from the Dublin Institute of Technology. I did have a PowerPoint presentation, but despite being from an Institute of Technology, I'm quite technologically inept, so it's not working in this computer. But I do have my own computer, so if you don't mind, I'm happy to circulate the PowerPoint at a later stage to the organisers or via the organisers if people are interested. But apologies for the technical hitch. I will be talking about new families, social parenthood and child law, and in particular the issue that I'm looking at is the position of children being raised by same-sex couples, which is I suppose a very new phenomenon in very many respects, but an increasingly relevant one. So the purpose of my presentation is to address the legal position of children being parented by same-sex couples, and in particular to consider the scope for improving recognition of social or de facto parents, that is, parents who are I suppose parenting children but who are not the biological parents of those children. So that's the main purpose of this particular presentation. In this regard, I suppose I wanted to take a child-centred approach. Clearly the best interest of the child in Irish law and indeed in international law is the paramount consideration. It's not the only consideration, but it is the paramount consideration. And I think in particular when we're talking about children being raised by same-sex couples, no less than children being raised by opposite-sex couples or lone parents, that the best interest principle is very important to keep at the centre of our considerations. The key principle then, therefore, is the best interest of the child being paramount. But also I think it's important to note that the child's relationships with all of the people involved in his or her parenting are valued and facilitated in a manner that best promotes the interests of the child, and that the law in particular facilitates stability and security for the child in the environment in which he or she is being raised. And this might be an unfamiliar topic for many, perhaps for some of you, but lesbian and gay parenting by same-sex couples is already a growing reality. We're not talking about some possible future scenario, but it's already, as I say, currently reality. You have many children who are born as a result of prior heterosexual relationships to one or other of the partners who is now in a same-sex relationship. You also have increasingly children born, particularly to lesbian couples, as a result of either a formal or informal arrangement involving donor insemination. Surrogacy, clearly a controversial issue, but that's increasingly becoming a prominent issue. Adoption is possible in circumstances where, well, I suppose an individual in a cohabiting same-sex relationship may adopt a child. Joint adoption by same-sex couples or civil partners isn't possible, but it's always possible that one or other partner may be an adoptive parent. And fostering, as we've seen, I think in more recent years, has become also more common. Same-sex couples, again, particularly lesbian couples, have been involved in fostering arrangements. The difficulty, I suppose, that I wanted to identify and explore is that for same-sex couples, it is effectively not possible, otherwise than in unusual circumstances or exceptional circumstances, for the non-biological parent, the social parent, to acquire guardianship. And guardianship, of course, is the key, the access point, the gate to a wide variety of other rights and indeed obligations that are enjoyed by parents. So with some limited exceptions, guardianship, or what the Law Reform Commission has suggested or has called parental responsibility, is usually confined to and predicated on being a biological parent. So social parents, those who are caring for children but who are not actually biological parents, even where they are civil partners, find it very difficult to acquire guardianship. A social parent may only become a guardian in very exceptional circumstances, usually that involve the death or removal of an existing guardian. And this in turn can have or present difficulties in relation to custody, although social parents do and are entitled to seek access in respect of a child in respect of whom they've been in loco parentis. Seeking custody if you're not a biological parent is more or less out of the question. The decision of the Supreme Court in J. McD versus L, I think, illustrates the problem. This is a case involving a lesbian couple who wanted to have a child, and they made an arrangement effectively with a friend of theirs that he would effectively help them to have a child. The original arrangement or agreement was that he would, while he would have some some involvement in the life of the child, that he effectively accepted that the lesbian couple would be the parents of that child. When the child was born, his attitude changed in this regard. He wanted or sought further involvement in the child's life. The lesbian couple objected to this. He brought the matter before the courts, and ultimately the Supreme Court granted him access in respect to the child, but not guardianship. The Supreme Court decision, as I said, illustrates the legal complications that may arise from parenting arrangements involving same-sex couples. The Supreme Court decision in particular confirms that fathers retain rights and obligations notwithstanding any agreement to the contrary, and that a sperm donor will always be a father for legal purposes. A same-sex couple with children are not considered to be a family for constitutional purposes. And thirdly, that the social parent has no legal status in Irish law. I think the decision is particularly interesting in that regard, that the social parent, the person who is not the biological parent, was considered to have no rights or indeed obligations in respect to the child beyond reasonably minimal ones. Nonetheless, the court did note that the environment in which the child was being raised was an important factor in considering what was in the best interest of the child. For lesbian and gay families, the J. McD versus L case is not entirely bleak. In particular, several of the judges consistently and quite regularly pointed out the child was being raised in a loving and a caring environment. Mrs. Justice Denham, for instance, said the respondents have lived together for years in a loving relationship. They provided a settled and loving home for the child. And these are factors that are critical and of importance in assessing the welfare of the child. These are important factors. But nonetheless, the decision overall, as I said, illustrates the conundrum of a same-sex couple who are raising a child that only the biological parent is recognised as having obligations or indeed rights in respect to the child. The Civil Partnership and Certain Rights and Obligations of Cohabitants Act 2010, while creating an extensive new status for registered same-sex couples and while containing some peripheral recognition of children who are being raised by same-sex couples, largely failed to address this particular issue. The Act largely proceeds without reference to children being raised by same-sex couples. It seems to effectively regard the adult members of the family as the sole, if you like, the sole consideration. So there's very little regard to children being raised by such couples, and that presents a variety of difficulties for couples for children being raised by same-sex couples and civil partners. In particular, the social parent has no enforceable obligations in respect to the child. And I use that word obligations deliberately. The social parent, even if they have shared in a decision which has brought that child into the world, that social parent has no or very few legal obligations towards the child. The child has no right to be maintained by or to seek provision from the estate of a social parent. The social parent is theoretically excluded from decision making in relation to the child, and I argue that this has a potentially destabilising effect on the child and indeed on the family. And in particular, the implication that's being put out is that the family is second class and not worthy of recognition or protection. The Law Reform Commission has recommended in its report on the legal aspects of family relationships a possible solution. In its draft Children and Parental Responsibility Bill 2010, it suggested that spouses and civil partners of parents should be able to acquire parental responsibility, what they call guardianship, either by the agreement with all existing guardians or alternatively by means of a court order, if it is in the best interest of the child. And I think it's always the central issue. It must be in the best interest of the child. It may not necessarily be so in every situation. The Law Reform Commission also made recommendations in relation to the extension of custody and access, which address some, although not all, of the issues that I suppose affect same-sex couples with children. The Labour Party in 2010 proposed a Guardianship of Children Bill 2010, which part of which suggested that persons in loco parentis in respect of a child, in other words those who are effectively in the place of a social parent, would have the right to apply for guardianship and custody under their legislation. And so I think that might be an intimation of things to come, that already the government of the day considers that this is an important issue. I think nonetheless it is important to bear in mind that the situation of lesbian and gay couples raising children, it can't be equated directly with that of a heterosexual couple, both of whom are the biological parents of a child. One has to have regard to the fact that there are other individuals involved, and in particular one has to have regard to the child's right to contact with other biological parents, as illustrated in McD versus L. I think particular care is needed in the context of surrogacy. There are huge ethical concerns in this regard, and in particular care is needed to ensure that donors and surrogates are not exploited, and in particular that we're not I suppose, putting people in a position where it's possible to effectively rent out a womb, if I can put it crudely. I think it's very important that ethical concerns are taken seriously in this regard. In relation to sperm donor arrangements, it's important to ensure that the donors involved are fully informed and that there's provision for counselling and support for donors. And in this regard, I think that, again, McD versus L, I think illustrates the kind of pitfalls that may arise in this context. The Commission on Assisted Human Reproduction in 2005 made recommendations, I think, that in particular could be taken on board in this regard. I think that certainly extending the possibility of guardianship to civil partners and spouses of parents would be a good step forward. It in particular offers a potential for greater stability for the child in the family in which it's been raised. It enhances the authority and indeed the obligations of the social parent, an individual who may have effectively, particularly in the example of a lesbian couple who secure a donor who assists them in having a child. The couple in those circumstances have taken a joint decision to bring a child into the world, and it seems anomalous to me that one of those couple would not be subject to any obligations in respect to the child. So the possibility of extending guardianship and obviously other changes would be required as well, would enhance the authority and indeed the obligations of the social parent, and would also provide important recognition for the family. It would confirm effectively that a child's family life is recognised on an equal basis to that of other children. And so while I think in conclusion that some care is required in this regard, the time has very much come to to grasp this particular nettle. In the civil partnership legislation, the government at the time, while bringing forward a very extensive piece of legislation, largely avoided this issue, left it kicked to touch effectively in relation to what is admittedly a complex and intricate issue. But nonetheless, I think it needs to be dealt with. These are complex and intricate situations that require a consideration of a complex matrix of relationships between the child and several important people in his or her life. And certainly there's need also for proper regulation of assisted human reproduction and provision for parenting resulting from such arrangements. But I think that it's important, crucially, to ensure to the greatest extent possible that stability and security for the child is to the fore. The child effectively feels secure in the environment in which they're being raised, and that there's greater recognition and support in particular for social parents, for those who take on the mantle of parenthood even though they don't necessarily have a biological connection to the child. So I think that's my 10 minutes. Thank you very much.